Okay, so it's recording. Fantastic. Okay, I just want to finish off what we're doing with sentencing. There's nothing else here that for the next couple of minutes. There's nothing in this sentencing last little piece that you need to know for your exam. So just kind of like listen in, but this is where we're up to, I think. So I think we closed off with finishing chatting about pre-sentence reports. Um, and there's different types of pre-sentence reports, and I guess what I'd like you to know or like you to remember is that I, context is everything. So it's the idea of who wrote it, um, for what purpose, and yeah, what kind of, I guess, yeah. So who wrote it and what purpose? That should cover it off really for all I really need you thinking about. Um, So pre-sentence reports, they include sometimes just oral reports given by, and they're generally prepared by probation officers, so community corrections officers. Um, so they'll include oral reports, short same-day reports, or what we'd call PAC reports, or provision of advice to court reports, and they're the kind of the big daddy gold standard of them. Um, yeah, as I say, so there's your context of it. One of the things to think to one of the things I found, like as an illustration, I guess, of the different subjective or the different views that people have um, about these kind of reports. Um, there was one probation officer who declined, who was doing a report on an address for somebody, and they declined the address and said there was drug paraphernalia at the address, which is a good reason not to approve somebody's accommodation. Um, and when pressed on that, they eventually admitted that when they'd gone round there, there were some Bob Marley posters on the wall, and that was enough to be drug paraphernalia and um, and a report going into the court saying an unsuitable address. So yeah, this I guess, as I say, it's not examinable, but it's just when you are looking at reports, think about who wrote them and think about why they were written. Um, okay, cultural reports. Now, Section 27 is reflective of, as I've kind of said before, a lot of the rest of the Sentencing Act is then bound up within 7, 8, and 9. And this is reflective of subsection or paragraph 8J. And we are, sorry, 8I. Um, Yeah, so cultural reports, this information, you would have heard that it's no longer able to be funded by legal aid. That happened around about a year ago. And I've got comments on that in the courts book. So both this section, I'll put it this way, this section on cultural reports, the next one on restorative justice and victim impact statements, you'll find that all within the course notes. So what you kind of need for that is in there if you need to know. But yeah, as I say, culture reports reflected in 8I. The information that's needed in terms of cultural background, the background to the offender's life, I really is still needed to be given in. It's still required, right? It's just not able to be funded by legal aid. So somebody else has to write it. And of course, this is the tension. Lawyers will probably be the ones who have to will be the ones who have to then write that or be responsible for it anyway. There are other kind of, I guess, workarounds where psychologists might write about an offender's background information or their cultural background. Of course, as you can imagine, that's just another professional writing at their hourly rate, the same to the same thing. So a psychologist will be funded by legal aid. But if you had a dead and will write a cultural report and to be funded to do so. But if it was I guess the thing is, if it was a dedicated cultural report writer, that's who are now no longer funded to write the same things. So, yeah, I don't want to dive into it too far. There's stuff in the notes. Restorative justice, and of course, in the Sentencing Act, Section 10 tells us that judges have to consider any restorative justice or any looking to make restitution or any goodwill really between the offender and the victim, any resolution to the whatever went on. And so an RJ report will come back and cover off things like remorse, as a restitution, what each of the parties, both the victim and the offender, what kind of support networks they might have in the community, and the impacts and the greater, wider impacts of their offending. So it's quite a holistic kind of way of thinking about it. Again, for those of some of you who would have done non-adversarial justice or just about any of this or any of the papers with Katie Tom, you would have come across RJ. I would say that restorative justice, when done well, has really good capacity to shape how we do sentencing. Although there are, as I've kind of got on the screen, it's not available to all, and I touched on last, not available to all. There's a voluntary aspect to it. Obviously, you can't force a victim to come along to an RJ conference. So if your victim's not into it, then you're not getting it. So you get none of the potential benefits in terms of a sentence reduction or discount from such a good question. I'll come back to Mustafa. That you get none of those kind of benefits. Restorative justice, look, yeah, it started being discussed back in the late 70s, early 80s, from outside New Zealand. And so it wasn't I guess, a New Zealand idea. And we introduced it first to here back in the 80s under what was the Children and Young Person and Their Families Act. So it was pitched as a response to the perceived rise in Māori youth crime. And so they said, hey, here's a indigenous styled process. Let's see if that will work to reduce our youth crime amongst Māori boys in particular. And so that and I guess the critique of it since then has been that instead of being designed around tikanga and therefore going to or directly answering the Māori issue, it is more it's a westernized device, kind of with some, or westernized scaffold anyway, kind of with some tikanga or Māori flavour kind of tacked on. So you might do a karakia, or you might be, we might do a hongi before we all sit down and get down to the real business of identifying who did what and who did what, who did what to who. So there are identifiable differences, I guess, between what would be a westernized RJ conference that exists within the ministry, within our justice system as we do it now, and maybe more of a tikanga based restorative justice process, which has different focus and has different measurables, really. And so, yeah, good question. It's come from overseas, and we look to kind of, yeah, we use it within the New Zealand context, but we haven't really fully, I would say, we haven't really fully indigenized it, made it New Zealand yet. It's still a lot of westernized European ideas. And yeah, I think that's about it. Just check. Okay, victim impact statements. Yes, again, as I say, I'll talk about these in a minute or later on in this lecture, we are going to get into victims by the end of this, so I'll deal with it then. But yeah, and as it gets covered off in Section 8 of the Sentencing Act, and Part 2AA of the Victims' Rights Act 2002. But yeah, I'll deal with that in the next module. And that's really my close to sentencing. And that's really I guess, all I'd really ask you when you thinking about sentencing is to remember what's really happening here. What are we looking to do? It's a formal legal exercise. We quote a statute. The Crown has its turn. The defence has its turn. The judge hands down a number. But something's actually going on underneath all that. And I would suggest that as a sentencing hearing reflects what society tends to fear, but it also displays both what it values and also what it likes the idea of erasing. There's certain things that within a sentencing context we prefer to just ignore. And a lot of that is around background and who is, I guess, arguing criminologically for a minute, who's really truly responsible for crime. So those things aren't, I guess, front and center when we're doing a sentencing. What we do look at is our values, which are around individualized justice, identifying who the offender is, whether they committed the crime, and then laying down a punishment for that. The wider ripples we tend not to think of, especially when we're doing sentencing. So it's about that. I think, unless we've got any other questions on sentencing that popped up, let's roll on. Good. Okay, so appeals. And these two modules are, as it happens, just about perfect to do from online. Not that I love online, and I'd much rather see people's faces, but it is what it is today, and I appreciate your playing ball with me. I know there's a family law exam starting today too, and so that's why our numbers are both a little bit down. And hopefully everyone that's doing that is off doing that happily and well. Right, so appeals. The vast majority of these, of how we work with appeals, can we please get access to the lecture? Yes. Okay. So you mean the PowerPoints, Joe? Yep. Okay. Because I didn't get those, did we? No, nearly there. Nearly there. Okay, so appeals should be in Canvas now under the appeals module, and we'll do that while and that will take us through to a break, and then I'll load um, victims into the victims one at the break. Okay, jump back to going. Okay, so yep, as I say, in appeals, most of our rules for these sit inside the CPA. Effectively, what I need you to remember out of this whole thing, appeals just don't exist out of nowhere. They don't just pop up into existence. There's no inherent jurisdiction to appeal. So I guess today's session is about unpacking that a little bit, just a little bit of that structure. We're not going to go deep diving into it. So we're going to try and figure out when is an appeal possible, what kind of an appeal it is, and then maybe how the appellate courts might deal with it. We're not going to get into the decision-making process, but effectively once it arrives at appeal, that's kind of where we'll stop thinking about it. Right. So there are two big categories, main ones, appeals as of right and appeals by leave. So the term by leave just means that the court has to give you permission, right? So you're not guaranteed the appeal will be heard. It's at the court's discretion. So, and as of right or an appeal of right is what it sounds like. You don't need the court's permission. You can just say, I want to appeal, and provided you're within time, that's good to go. But even in those kind of cases, so there might be other forms of approval that might be needed. A prosecutor's appeal, for instance, a sign off on a prosecutor's appeal has to get a sign off from the Solicitor General. And so that's sometimes a little bit of a gatekeeper. But for now, this is your first major kind of difference or, separator between the two types of appeals that you need to know about. So appeals as of right. So they are situations where a party has the right to appeal without leave from the court. And this happens a few times, and these ones you do need to know. So firstly, when a defendant is making their first appeal against either a conviction or a sentence, so sections 229 or 231 of the CPA, or when a prosecutor, as I just mentioned, a prosecutor has its first appeal against a sentence dealt with in sections 246 and 248. As I said, when we're dealing with prosecutor appeals, they still need a sign off from the Solicitor General, who's effectively just the big boss of the prosecutors. But once that's done, the appeal counts as an of right appeal. Other situations is where a first appeal against a contempt of court finding, covered in sections 260 and 262. If there's a first appeal against a costs order, 271 and 273. And also a first appeal against a suppression decision. And so that's in sections 283 and 285. Okay, so first appeals against contempt of court, costs, and suppression. Okay. There are a few others scattered across different statutes, but you don't need to worry about those for this course, just these ones. Okay, so if you're dealing with appeals that fall into this category, and this is really the first step, identify what is the purpose of the appeal. What's the reason you're appealing? If it's one of these, you have it as of right. And yeah, are we all cool with that idea? That list? Ka Me, appeals by leave. And then to capture pretty much everything else requires leave. So your second appeals or any Supreme Court appeals, which would be in most cases second appeals, requires leave. And I mean, it's a the idea behind that is there's a sort kind of a signal to the court that a second appeal has got to be rare, right? It's not a routine thing. There's a higher level of importance that's got to be attached to the case or the facts of the case and the potential outcome of it in order for that second appeal to be heard. We'll get to that in a minute. Yeah, the general idea, as it says, is it allows appellate courts to manage their workload and to filter out unmeritorious claims, right? Because let's be honest, if you were just appealing everything, then you're going to have a whole lot of rubbish appeals, and it's just, our court systems will get clogged up. Some defendants appeal just out of pure desperation or because they are just fed up with the system and they just want to be annoying. But this idea of having leave, or we'll let you have a first appeal, but after that, once if you haven't got anything really fundamentally important about your case, then that's that really, unless we, as I say, we can find that within our leave rules. Okay, and of course, when you think about it, that just keeps things fairer for everyone, taxpayers, victims, witnesses, just the general system, right? We don't want to be dragging everybody in to relitigate previously decided facts or things that are so really insignificant in the scheme of the wider picture of our criminal justice system that we are wasting our valuable appellate court time. And so not generally, but the higher up the system you go, the tougher it gets to be heard. In the Supreme Court, of course, that bar is super high. You are going to have a very good case in order to get to the Supreme Court. And it's not just a good case of you've got good facts behind you, but in order to be heard by the Supreme Court, they won't grant leave unless it's necessarily in the interests of justice. Okay. And that usually means one of three things. So it means Supreme Court will say that they'll hear an appeal if it raises an issue of general or public importance, if it raises an issue of general commercial significance, not an issue for this course, of course, or and more likely that there has been or could be a substantial miscarriage of justice. So if those things are in play, then the Supreme Court will look at it. Also, something else to remember, refusal of leave is final. So if the court says no, it doesn't want to hear your case, you don't get a second bite at it. All right, Section 213 of the CPA pretty much closes that off. And lastly, I've got a note there, only a party to the proceeding may appeal. So if I saw a decision of the Court of Appeal that I thought was wrongly decided, that had nothing to do with me, but that I thought, hey, Justice Winkelman and the rest of them should have a look at this. I can't appeal it up to the Supreme Court, as you can imagine. But I wouldn't be the first person to try. So, but them's the rules. Okay. So here's our table. And this is where the appeals go to based on the original decision. Okay, so, and the original decision isn't necessarily the first decision, it's just the decision we're looking to appeal. So, I'll explain that sentence by this way, by saying, let's say you had decision made in the district court, and then that was appealed. It was a decision, let's say, on conviction, and that was appealed, and that appeal gets heard. If it was a jury trial, gets heard at the Court of Appeal. If the Court of Appeal hear it, that's the original decision is the district court decision. If I then appeal the Court of Appeal decision to the Supreme Court with leave, and I get granted that leave, the original decision becomes the Court of Appeal decision. Okay, and the Supreme Court then hears that appeal. So for the purposes of my table, the original decision is the decision that you're appealing, not necessarily the first decision. Cool? Assuming you're all cool. So if the first decision was made by a justice of the peace or a community magistrate presiding in the district court, so we're talking about a category 1, category 2 kind of offence. If you're appealing that, you will end up in front of a judge in the district court. So one step up from the magistrate is a judge, but still in the district court. If you appeal that, you're going by leave to the High Court. Cool, nice and simple. If you are looking at a category kind of like 3 offence, category 4 offence 2, but a category 4 will be in High Court. So a category 3 offence that was presided over by a judge in a JAT, so it could also be a 2, okay, or the appeal has gone in before election of a trial in a category 3 matter, then your first appellate court is the High Court, and then you can appeal into a second court to either the Court of Appeal or directly to the Supreme Court. And obviously, if you get a further appeal, you'll be going to the Supreme Court if your appellate court was the Court of Appeal in the second stage. Okay. Now, the next row down, a judge presiding in a district court after election of a jury trial. So the defendant elects a jury trial. So you're talking in category 3 offence. If you're appealing that decision at any point from onwards, or any decision to do with it, from any point onwards after election of the jury trial, then the first port of call will be the Court of Appeal. Be unlikely to ever go directly to the Supreme Court. I can't think of any cases on that, although it's possible. But generally, the Court of Appeal would be where you go first, 99.999% of the time. And then, of course, up to the Supreme Court if needed. If your initial court your original court was the High Court, so you're on there was a category 4 charge or a particularly complicated category 3 charge, then of course one step up from the High Court is your Court of Appeal. There you go. If you were heard in the Court of Appeal, then you can only be appealed to the Supreme Court. And if you're in the Supreme Court, I'm not sure why there is in that second box on the Court of Appeal roll. I'm not sure why there's a court written in there. There's not one. And of course, you're not appealing anywhere from the Supreme Court. So are we all cool on that process? Any questions there? Nice. Okay. Right. Real quickly, if you're appealing against conviction, so this is for defendants who have been convicted, and you say, hey, I shouldn't have been convicted. And if you're appealing that, you've got 20 days from the date of sentencing to appeal. So not from the date you were convicted, from the date you were sentenced. That's when your clock starts. So even if you were found guilty months ago, and some people it can be 6 months before the sentenced. You've got 20 working days from the date that the judge imposes your sentence on you to appeal your conviction. And of course, if you're in the district court, in front of a jury, you're appealing that to the Court of Appeal. Okay. And of course, the same goes for, of course, for your sentencing appeal too. So if you're just appealing sentence, so you can choose to appeal your conviction, you can appeal, or you can choose to appeal your conviction and sentence, or you can choose to appeal just your sentence. Okay. And all of those, you have 20 working days from the date of your sentencing for the offence for which you have been convicted, right? And if you want to appeal that, all good. Real car, yep, nice. Good, good. Right. And this is kind of really where it starts to get into it. Section 232 of the Act. So 232.2 lays out the test for when an appeal against conviction can be allowed. So there's three gateways, or three ways this can happen. Three ways you can have your appeal against conviction allowed. Firstly, the court finds that the jury verdict was unreasonable. Okay, unlikely for that to be happening. Keeping in mind, the idea is that juries are there as fact finders. Questions of fact aren't appealable. So if you're just saying the jury got it wrong, it's going to have to be a high degree of evidence that you are bringing to make that case, right? Because yeah, you're going to have to show that they're objectively speaking, that the verdict wasn't only incorrect, but that it was unreasonable. And so it kind of goes to the next step. As I say, it'll be rare that you come across many of these. Judges, especially in appellate courts, are wary about wading into decide how juries made decisions in original courts. So, and that's kind of what they're required to do should they have to assess the unreasonability, the unreasonableness of any evidence assessment. So I guess it's a if you're having to rely on that as one of your grounds, you're probably pushing it uphill. The second gateway is if there was a miscarriage, you're able to show a miscarriage of justice in a JAT, so in a judge alone trial. And usually that would come up, or you'd be able to show that through maybe something like misassessment of evidence. Again, this goes to this question of was it a question of law or a question of fact? And if it's a question of law, again, your appellate judges are going to be wary about stomping on their lower court judges' feelings about the law, especially if it has to reach the level of miscarriage of justice in order for that appeal to be allowed. That's a higher, as you can see, that's a higher level than just they might have got it a bit wrong, or they didn't quite analyze the law correctly there. You have to be able to show a miscarriage of justice. So higher bar. Or thirdly, a miscarriage of justice more broadly. And that's really, I guess, where most appeals kind of sit. Weirdly, not weirdly enough, but that's where they're from. And so for the rest of this little section, we're going to talk about how do we define what a miscarriage of justice is, what are we talking about when we say one of those things, and what are we particularly looking for within the act to be able to say, hey, this meets the level of a miscarriage, and therefore an appeal should be allowed. So that's kind of what we'll look to do for the rest of it. Okay, so as I say, as we try to lay down these rules or these a bit of a process for it. I'm going to tell you now that what a miscarriage of justice is a very flexible concept, because it includes ideas just like errors or irregularities, or just about any event that creates a real risk that the outcome of a trial will be affected, right? Um, or if a trial is unfair not in any way, but in a particular way, or that we would call it something called a nullity if we nullify the trial. So there's, as I say, lots of different ways and very context specific ways that these miscarriages of justice can occur. Right. So we're looking at more than just errors of law. Right. Errors of law are easily dealt with within appeals, but we're kind of assessing. We're looking to assess the impact on the defendant or the proceeding in general, right? So we're not just saying, oh, there was some errors, there was some mistakes. We're looking to say what was the impact of those mistakes? That's the real kind of test of a miscarriage. So let's start with an idea of errors or irregularities. Um, they can be legal errors, say wrongful admission of evidence. If a judge allows hearsay evidence to be admitted when it shouldn't have been, that's just considered a wrongful admission. That's where that can kind of sit. They can also be practical mistakes. So, if a guilty plea gets entered based on bad legal advice, for instance, that counts as an error. Okay, so it's not just. I'll qualify that by saying you can't just go, oh look, as a defendant, you can't just go, oh, I regret saying guilty before. I really want to go not guilty. You've got to be able to show that there's, I guess, genuinely exceptional circumstances around that. There's reasons for the error. Um, well, not even the error. There's reasons for you changing your mind, and therefore, having made an error, and now you're fixing that error. You're not just saying I've changed my mind. See kind of the difference. Like there was a there was a mistake made, and now we're trying to fix that mistake, as opposed to I just didn't really want to do it that way. Okay. Can't really think of any other ways to explain that. But yeah, so we're looking for either legal errors or practical mistakes that occur. Okay. Unreasonable verdicts. This one's a little bit tricky, and I won't test you on this because it's kind of what we're talking about. So a verdict's unreasonable if no reasonable jury or a judge could have reached that decision on the evidence. Right. So um, it's not just there's a better view, right? So the appellate court doesn't just like sub in its opinion or its belief on what should have been decided and then just go, that's the answer, right? You are not just looking for a second opinion. So, not like when you go to a doctor, if you don't like what your doctor says, just go off to get a second opinion, and that kind of then becomes the one you listen to. It's not like that. This is more, it has to look at whether looking at I guess, the whole picture, giving due deference to the trial, the initial trial itself, and the court that it was held in, and all of that kind of plays in. Can the verdict be sustained? Was kind of really the question. Like, is it reasonable to do that? And that's a legal question, right? So reasonableness, it's an objective standard, it's a legal question. And so and it's a smaller window, tougher bar, higher threshold to get through than just, hey, you could have decided that differently. Okay. So yes, in most cases, there will be other ways to assess or evaluate a case. But that's not what the appellate courts are looking for. They're looking for unreasonableness of those decisions, not just could have done that better. Okay, I hope that's clear. I hope that's clear. Find out. Yeah. Right, okay. Yeah, so carrying on. The idea really is that you've got to kind of ask yourself, did something go wrong that creates like a real possibility, a realistic, not just a theoretical one, but like a real possibility that the outcome of the trial would have been different if that thing didn't go wrong. Like if that didn't happen, if that went okay, then we would have been fine. We would have had a substantially different decision. So, and yeah, so the trick is, so it's yeah, as I say that. So that quote there, a real risk that the outcome of the trial was affected. That's what I am looking for, I guess, in your exam question on this. That's that assessment I'm kind of looking for you to do. Okay, if there was an exam question on this, of course. And the appellant or the one, and it'll be the defendant in this case, the vast majority of the time. It's up to the defendant to both identify the error and then show why it mattered, right? And it's easy enough to show the error. Your Honor, the judge allowed some hearsay evidence in that shouldn't have come in. Let's say, but then proving it created the real possibility of the risk, the realistic possibility of a different outcome or an unreasonable outcome. That's a tougher thing to show, right? That's the harder bit to prove. That's why not every appeal gets allowed. Because throughout most trials, people are able to point to things that go wrong, whether it's little procedural things or legal things, and those aspects of any trial would normally be appealable, but because of this I guess the greater threshold, the idea that you've got to both identify the error and then show its real possibility, the realistic possibility that it matters somehow to the outcome. That's the tougher bit. Yeah, probably said enough. Okay, another ground of appeal. Where am I? Unfairness of the trial. Right. So unfairness. So this is different from saying that the outcome might have been wrong. You can have a totally correct verdict, but if the trial was conducted unfairly, the conviction still can't stand. Okay, so there's no statutory definition of what makes a trial unfair, and in reality, there's not really too much case law around it either. So as I say, what I need you to take away from this, from the unfairness of the trial idea, what we're saying is a fair trial is one where the law is accurately applied to the facts, and then those facts are determined impartially. Right? So that's how I would define a fair trial, is the law being accurately applied to facts, and then those facts being determined, or what happened, i.e. the facts, being determined impartially by an impartial determinator, decider, right? So So I would say, and case law does back this part of it up, if you don't meet that standard, the whole thing gets compromised. Now, as I say, why this is different from the real risk that the outcome was affected is because what we were just talking about, the real risk of the outcome, the real risk the outcome was affected kind of ground, that's about whether something went wrong and then might have changed the result, and therefore you end up with a wrong result. Okay. Trial unfairness is different. So as a trial unfairness is the result might be correct, but the process was flawed. Okay. So example I've got here, apparent bias or even real bias. So even if the judge or counsel wasn't actually biased, if they looked that way to a reasonable, informed observer, that can be enough. So that, the ordinary person kind of test. Maybe the judge said something in open court that crossed the line. Maybe there was kind of some kind of perception that they weren't treating the parties equally. Something was going on that flawed the process. Right? So we're not necessarily saying the outcome was wrong, saying the process was wrong. Another one might be overly firm case management, especially in judge-alone trials. Sometimes judges have been known to, I guess, give the impression that they're no longer being impartial by coming down too much into the arena. So, like I was touching on with bias, but it's more about just this, not allowing enough party autonomy going on, and the judge getting too involved with case managing. Right? There's issues with that. Other ones are if fresh evidence comes about. So if something new is uncovered, say forensic evidence that you didn't have at trial, or a key witness pops up and says, "Hey, I can help with this," that's usually handled under the miscarriage of justice ground. But it's also tied to the idea of unfairness. Okay, because the question becomes, does that new evidence create a real risk that the outcome would have been different? Then if yes, it might justify it admitting it on the grounds of the like I was saying, the previous section, the previous part, the real risk, the outcome might have been affected. But if the outcome wasn't affected, but it's created unfairness by the fresh evidence suddenly popping up, generally be a timing thing, that can be something that then falls under this kind of assessment. Okay, so again, really, I guess, fact specific, and should you get assessed on this, should there be a question on it, that's the kind of thing you're looking for. Those final decisions of whether the appeal would be allowed or not is kind of neither here nor there. But the grounds on which you make that appeal application will be different. So you've got to kind of assess, has there been a breakdown in the process that then created a wrong decision, or we not so much, or that then created, has there been a breakdown in the process that then created a decision that we're not even really worried about? It could be right or wrong. Or has there been a breakdown in the process that absolutely created the wrong decision? Those are two slightly different positions to take at the outset, right? So a slightly different analysis. Okay. Right. So the test isn't so much whether the verdict is proven to be unsafe. The decision isn't our issue. It's whether there's a realistic possibility that any new evidence or the bias that you could show existed or allege existed, that undermines the safety of the conviction by its unfairness. Okay, so yeah. Yeah, as I say, if you could, other examples are where statements from defendants get admitted in breach of admissibility rules. Um, Other improperly obtained evidence, so evidence that would have been excluded under Section 30, that say came in through breaches of rights, that's allowed in when it shouldn't have been. Or just prejudicial material that was too prejudicial and should have been struck out at 8. The question is that enough, right? So the unfairness ground, I'll try and sum it up like this. The unfairness looks at the trial as a whole, right? Not just what went on, not what the individual errors were, but the whole process. Whereas your other tests focus on what went wrong and then the impact of that error. I know that sounds fun and muddy. That's why this is recorded, and you can go back and try and listen to it again, but also have a read through the case book. So I'm going to carry on. We'll finish off nullity, and then that should be us on and that will be all you need to know on appeals. See how simple it is. And victims is just about simpler. Nullities, right? So let's finish this off. This is effectively your most severe category of appeal, and effectively what you're saying when you say a trial is a nullity is it's got a fundamental procedural error within it, right? Something big happened. So it's not just a technicality, it's something so serious that it undermines the very legality of the trial itself. Okay. Most obvious would be if the court that conducted the trial had no jurisdiction to be doing so, right? So if you thought, if you had a category 4 offence being heard in the district court, that's a fundamental error. That would result in a nullity. Doesn't matter how well the trial went, doesn't matter how accurate the decision is, how grounded in truth it may be, has a fundamental error to it. Okay, and that would just be declared a nullity, and the whole thing would get thrown out and start all over again. Or something like if the charging document failed to allege a criminal offence at all, and then someone was tried and convicted. These kind of things are very rare to happen, but they have happened in the past. So here's one of the things: nullity. Like so many of these other ideas that we've talked about today, nullity isn't clearly defined in the Act. So it does pop up when you are talking about the definition of what a miscarriage of justice is, which doesn't really help us. But the concept, the idea behind it still matters, as you can imagine, a lot. Because if you've got a null trial, it doesn't matter how good the process looked. Okay, it shouldn't have happened at all, is really the point. So, and courts over time, and in fact, weirdly enough, different courts have taken different views on whether an error is fundamental enough to nullify a trial. So because different tests. And yes, if you had a jurisdictional issue, that becomes easy enough to spot as fundamental enough, but obviously we're working in the area of grey zones and fuzzies. So things like unsigned indictments, in some cases they've been treated as fatal to a case, but in others they've been considered fine and will just move along, and the prosecutor will get a bit of a rap over the knuckles, right? It all depends, I guess, on what the courts believe that the statute intended, right? So if you're going to argue for a nullity, if you're going to suddenly, if you're going to, if in your exam you suddenly, launch, just leap into arguing for a nullity to exist. You've got to know you're on solid ground, because you're going to have to be very specific about your claim. You're going to need to identify the exact irregularity that took place. You're going to need to tell us the purpose of the rule that was breached. So what was the rule that was breached? Why is that rule important? And how fundamental that is to the system. You've got to also tell us whether Parliament intended that non-compliance of that rule should nullify the trial. Again, high bar. You've got to be able to show parliamentary intention. That's not always easy. You will also have to show that there was, if there was any prejudice to the defence, and that will help. I mean, that will help your case, obviously, if you're on the defence. Although even if you, no, I won't go there. So those are the things you're going to have to be able to show. Some irregularities, as I say, won't cut it. Minor defects in documents, errors within, especially within witness summonses and things. So things that don't directly impact the defendant, they might even seem to you at first glance to be fundamental to the procedure, but you've got to kind of spot this idea of prejudice to the defence, right? But no, but in saying that too, an absence of prejudice isn't always enough to save it. So you can still have a null trial without any prejudice. So just because the defendant doesn't get prejudiced doesn't mean that the appeal is over, right? Or that you can't argue for a null trial. So if it was only witnesses that were impacted, for instance, you can still argue for a null trial, provided you can show that irregularity, that you can show that the purpose of the rules around those witnesses, that the purpose was breached, and that Parliament intended non-compliance of that rule would result in a null trial. If you can do that, you're kind of getting there. But as I say, high bar, guys, high bar. So here's probably the best way to distinguish a nullity from unfairness. Before we were trying to distinguish, I guess, unfairness from the real possibility of a wrong outcome. Here's where we're distinguishing nullity from unfairness. So unfairness, as I say, was about how the trial was run. Was it impartial? Right? Was the law applied properly? Did they apply Section 30 of the Act properly? Right? Nullity is about the overall picture of what was done. So did the court have the power to do what it did? Was the act followed within the context of parliamentary intention? Right? Bigger questions. So think of it like this, I guess. An unfair trial is a broken process, but a null trial is an invalid one. Okay? Broken, invalid. Okay. That's about all I need you to know on appeals, guys. Any questions now before we kind of take a 5-10 minute break? No, kapai. Okay, give us 10 minutes. I will be back here with a nullity required declaration by a MP, and an MP, the Minister of Parliament? No. No. So when I mean by parliamentary intention, it's a statutory interpretation tool. So you can sometimes look at a statute and go back to look at most statutes will have a purpose section where you can go and look at what is the purpose of that statute. And if you really got into it and were looking to, I mean, if you were making an application to the Court of Appeal on a nullity claim, you would do the research and go back and look up the Hansard debates around the passing of that particular bill at the time and then the act. You would look at any amendments and the debates around those to try to get an idea of what was Parliament really thinking. Good question, but yeah, it's not kind of good question, but it's kind of like, so that's how when I say parliamentary intention, that's what I mean by that, rather than calling MPs. But yeah, fair enough. Does that answer your question, Dihan? Hope so. Okay. 5:09. See you back here at like 20 past, 10 past. So yeah, we'll see you back here in 10 minutes, and I will now load the victims slide PowerPoint into the victims module up on Canvas for you, and I'll see you in 10 minutes, guys. Okay, so let me just see what I'm doing. Okay, so I'm assuming you can all see victims PowerPoint. Nice. We'll get through this by the close of lecture, and then we're on track for a bit of revision and a bit of a chat next week, and life and real for real, IRL, they say, the kids say online. So, okay, victims, here we go. You'll recall that, we've talked about this a fair bit. The prosecution of criminal offences is primarily the state's job. Sometimes we have things, private prosecutions, of course, and I'm working on a really interesting one at the moment, but generally, overall, we are looking at state prosecutions, so state-run prosecutions. So really the whole thing is just framed as, the Crown and Smith, Crown and Jones, the state versus the defendant. But where does the victim fit into all of this? And this is kind of, I guess, really, this is my main question that I want you thinking about when you think about victims, both where does the victim fit in and where should the victim fit in? Oh, have I? I knew. Thank you, Mere. It feels like the victim one. Of course I did. Let me have a look. I did too. There's just not enough coffee in the world for me to try that again. Victims. Yeah. Promise that's done properly now. Okay. I'll chat away while those of you go and find it. Thank you for that, Eddie. Good stuff. Okay. So where was I? Yeah, that's kind of where I want you thinking about both where does the victim fit into this whole thing, and then kind of where should they fit in? Because in reality, they're kind of peripheral. Doesn't mean they're not important. Far from it. In fact, victims play a crucial role in some moments within the whole process, but especially at sentencing. As we just talked about, sentencing comes up in RJ. What else? Parole, bail hearings. So things that we're going to talk about over the rest of this thing. But it doesn't mean that they aren't voices um, within those little systems. But they are very much peripheral to, in particular, the trial. Okay, just the whole prosecution side of it, the process of prosecution, largely very much on the sidelines. So, yeah, I would say that's come about, like why we're here, why we're in this position where, I guess, victims are peripheral to the process, has been shaped quite heavily by historic and institutional forces rather than, I guess, active policy design. So it's kind of it's a natural, organic outworking of our system rather than political will at any particular point. Okay. Um, so let's start at the beginning. Um, Always, as we say, a good place to start. Um, of course, most prosecutions begin with a victim reporting a crime. Generally, it's an obvious starting point. But what happens once the police get that report? The process becomes entirely theirs, okay? Because police can decide, after receiving the report, of course, they can decide not to investigate any further. They can put that report in a drawer and leave it there. Or they may go out and do an investigation and then find that there's just insufficient evidence to either continue any investigation or insufficient evidence to lay a charge or to prosecute, right? So and there's prosecution guidelines that set when those things should occur. But my main point is this is not up to the victim to decide, right? Police get to decide whether prosecutions continue even if the victim retracts their allegation, right? So the victim says, I don't want to do this anymore. The cops still have the right and, in fact, the obligation to carry on with both their investigation and any prosecution, provided that the victim's statement isn't so central to the case that their whole case falls over. Okay. And so that idea, that very concept that you have unwilling, sometimes quite often by the time you get to trials, you've got victims who are unwilling to give evidence or not happy at the very least about giving evidence. That backs up the idea, the notion that a criminal offence is a public wrong. Right? It's an offence against the state. It's not a private grievance between individuals. Right? It's tort law. Go and talk to Mr. Beaver about that. But what does that mean, I guess, for the idea of victim agency? So, because effectively, once a report's made, the victim becomes only a witness to be managed, right? Rather than a participant with rights and obligations that attach to them, whether that be from an alleged offender, whether that be from the state itself, whatever that position of a witness is, a victim is, they have become nothing more really than a witness in a trial. Okay, that's what I'm saying. At this point, they're still very much peripheral to the prosecution. And this creates, I guess, a rather stark tension between the emotional investment of a victim, as you can imagine, quite often is very high, and their standing within the overall criminal procedure. I know those two things sit at tension, really. Where you've got one very high emotional investment by the victim, but they're quite often psychological and emotional trauma attached, sometimes physical trauma attached to an offence. And then we kind of say, well, that's cool. You can come along to court and tell us about what happened to you, but that's about it, right? And these, and I guess that the step or the pedestal on which you place, or how high in the tiers that you place a victim within our criminal procedure framework, it's generally pretty low. Our courts place them pretty low down on the importance scale, if you know the best way to explain it. Right, something else. The prosecutor, of course, gets to decide whether the victim will be called to give evidence. They are, as I was just saying, they're a witness. There is no duty on the part of the prosecutor to call the victim, and the victim has no rights to demand to be heard, to have their day in court. Right. In fact, they can be compelled, of course, to testify even if they're reluctant or hostile, even. So, effectively, though, I guess that can be summed up. The victim has no real control over how their evidence is used or not used, right? So while a prosecutor should, and does, there's rules around it, while the prosecutor should keep the victim reasonably informed on what's going on, they're not taking instructions from them. Right? As defense counsel, you're not really supposed to do anything in court unless you've got instructions from your client to do so. When you're the prosecutor, you don't need to be going back checking with the victim, getting instructions from them about your case. In fact, I guess the opposite is just about true. Some have said that too much contact between a prosecutor and the witness can actually undermine the prosecutor's independence, when the role of a prosecutor is to maintain that kind of impartial public interest lens over the whole prosecution, not suddenly find themselves being the advocate for the victim. Okay, there's some mitigations to that though. Parliament has allowed for, before when I was talking about these most of the rules around victims have developed out of our common law, out of court-made law, as opposed to parliamentary intentions or such, or, parliamentary ideas, legislative ideas. Parliament has introduced things like CCTV, or as alternative modes of giving evidence. So you can give via CCTV, or from behind screens sometimes, to reduce the trauma of giving evidence in court. So children or victims of sexual offences in particular. That kind of thing has been I guess, a specific legislative tool that our parliament's gone, hey, we need to provide some more protections around victims. Oh, great. The TCANG approach, would that be significantly different? Yeah, it would be. I mean, I will come back and talk about it. I'll do a brief kind of tikanga wrap up in class next week, because I kind of want that one to be in person. Yes, good question, Hugh. I'll come back to ways that we could possibly do tikanga based, how victims are treated within tikanga Māori anyway. Good question. Yeah, right. So the other things that the legislators put in place, just as mitigating mitigating this, I guess, rather harsh, or these harsh duties or obligations on the part of victims once they've made their complaint to police. One of them's around the idea that not the idea, the fact that self-represented defendants can't cross-examine certain complainants directly now. So Section 95 of the Evidence Act kind of covers that and protects victims in that regard. So what happens now is a judge will appoint someone to do that on behalf of the self-represented defendant, right? It's a small reform, but it's not nothing. And if you can imagine somebody who is a victim of, in particular, a sexual offence, being cross-examined by the person who they say sexually assaulted them, and that's a hard position to put somebody into, and so Section 95 of the Act protects us from that now. When I say us, victims from that now. So sometimes our legislatures step up and actually give us some real protections. But overall, very few times where a court is required to factor in the victim's interests. Okay, it doesn't happen very often. One time when they do is when a judge has to decide whether to adjourn a trial or order a retrial. The court has to consider the interests or how any delay might affect the victim. So, and again, when we're looking at 147 stay applications, the idea of undue delay around that, is also the impact on victims is also considered within that kind of a calculus. But yeah, as I say, outside that, and I'm really struggling to think of things that, in which victims kind of get thought about. Outside that, that's about it, right? So generally, so overall, it really is just this contest between state and defendant, not victim and offender. Okay, so what happened? Well, the legislative response. I've touched on a couple of them, and this other idea that was brought in back at the same time as the Sentencing Act and the Parole Act in 2002. They're kind of a suite of these acts. Was the Victims' Rights Act 2002. And the idea of this was to give victims a voice, or at least just some more standing within the whole overall process. And to be fair, I mean, it provides a framework. It's kind of about it. I maybe it's not so fair, but a framework is what it is. So Section 4 in the VRA defines a victim quite broadly, right? And includes the direct complainant, but also the parent or guardian of a complainant under 17 and immediate family members of someone who's died or been incapacitated by an offence. Okay, so however, the Act, I would say, is more symbolic than substantive. And that's kind of why I said it gives a framework. Most of its provisions are just declaratory. So Section 7, for example, says that victims should be treated with courtesy and compassion and that their dignity and privacy should be respected. Okay, so but so that's nice and that sounds good, but it's not a right that you can actually enforce in court, right? So you can't turn around and say, my dignity and privacy is not being respected, therefore, and then lay out a legislative solution for that, right? All you can say is, as a victim, my privacy wasn't considered. And the answer is often not much more than, oh, well, sorry. Okay. So as I say, it's not a right, right? These are just a framework. Yeah, aspirations, not obligations, right? Okay. So, and much like Section 8 does the same thing. So Section 8 in the VRA talks about victim welfare, talks about health, access to counselling, access to help with legal needs. But again, aspirational, not obligatory, and they exist, I would say, more in rhetoric than reality. What else have I got up there? Victims Code. Oh yeah. So the Victims Code that was issued 10 years ago now, so 2015. It was supposed to make this whole thing more accessible, right? It was supposed to just much like the Patients Code within the medical arena. This is the Victims Code. So it's supposed to compile all our, as victims, our rights and our expectations in one place. And so that we can all kind of go to that and find it. But in reality, it doesn't go beyond anything that's already in the legislation. It's user friendly, it's nice and easy to read, but it is not a source of any new entitlements. Okay, it doesn't help out any more than that. Okay, so I guess if I was to say what's the takeaway outside of those, it would be that although victims are being acknowledged more in statute, those acknowledgements aren't necessarily grounded in any legal authority, right? Or any ability to enforce those entitlements within a proceeding. Okay. Hopefully I've explained that clearly enough. Yeah. So despite all that, and I know that sounds quite cynical and negative about it all, but so despite that, and despite these limitations on our victims, there are a few areas where victims do have some enforceable rights, and they're not huge, but they are. We're going to talk on those for the rest of the time. So, Section 11 of the VRA is one of them, and it's what victims get is they get the real and out of 11, they get a real legal right to be told about the programs, the services, and the supports they can access, but only through the specific agencies listed, right? So it's not just everything, but it's a very limited set of information that victims have the right to access or be given. So, and the agencies I'm talking about are the kinds of ones who help victims through the system, practical support, as I say, counselling, ACC, financial help, that kind of stuff. Limited, but it's something. We also see some firmer obligations under Section 12 of the VRA, and so that's about being kept informed. So if you want to, as a victim, you can say, I want to know how the investigation's going. So, both during the investigatory process, but also as charges then get laid, you can say, I want to know what's up with that, whether there's been any changes to any charges, so amendments, additions, deletions, and then you also get to say, look, what the eventual outcome of the case is, right? So whether you ended up giving evidence or not, you still have the right to, under Section 12, to hear that, right? So, yeah, I mean, again, it's information. You can probably find that out if you just, within public record, that victims have slightly greater rights than the general public because of their status as victims out of Section 12. There's also protections or legislative protections for privacy. So the defendant doesn't ever get to find out the victim's address unless it's like absolutely necessary to ensure a fair trial, and that's high bar. So Section 16 and Section 16 capital A of the Act kind of cover privacy protections. And also when it comes to things like victim impact statements, which I'm about to talk about, so a judge can block parts of that statement from being disclosed. So especially when there's safety concerns within the VIS or the victim impact statement itself. So quite often judges will delete parts of it simply for the victim's privacy and their safety. It's kind of a weird thing. It's not a weird thing, but it's just a thing that judges do to keep an eye on the safety and the privacy of the victim, even if the victim wasn't quite aware of it. Cool. And I suppose that then brings us to, and we're getting very close to the end. Oh, no, we're not. Here we are. Victim impact statements. Here we go. As I said, I touched on those in sentencing, and this is where they come up, right? This is the chance for your victim to speak directly to the court, to talk about the impact that the offending had on their life, physically, emotionally, psychologically, right? The law is pretty clear on this and how it all works, that the preparation of a victim impact statement is voluntary. There's no requirement on a victim to do one. But if they do choose to engage and do that, then the prosecutor is responsible to ensure that it's done properly, right? Though I guess the burden then falls onto the prosecutor to ensure that that is done once the victim says that's what they want to do. So the judge gets to decide whether the victim or a representative of the victim gets to read the statement aloud in court. Sometimes that's allowed. Other times the judge just says during sentencing, I've read the victim impact statements. We don't need them read in court, but I've taken them into consideration in preparing my assessment of sentence. As you can imagine, reading out victim impact statements can generally be generally, I would say they're always a powerful moment. They're always an emotional thing. And for those of you who've ever thought to do it, I highly recommend it, is to go back and watch the victim impact statements out of the Christchurch the Masjid massacres. So the from 2019, and watch the sentencing of Brenton Tarrant within that, or not, watch not the sentencing, but in his sentencing hearing, watch the victim impact statements given by the families. So as I say, generally a very powerful and emotional moment in a courtroom, but very carefully controlled, because one of the things about victim impact statements is you're not allowed to include or shouldn't include allegations about the offender's character or unrelated events. So it's not a submission on the guilt or of the offender, or an opportunity or a vehicle to attack the offender, or to show any, I guess, retributive emotion or ask for revenge or anything. It's a as I say, very controlled process. So the victim can express a view on sentencing, but like what might happen or what should happen in the victim's opinion, but that view is by no means binding on the court, right? As you can imagine. So, yeah, it's because of the emotion that's attached to it. Yes. I said before that there are the safeguards for visitors, that the defendants normally don't. Oh, sorry. The defendants normally get a copy of the victim impact statements, but they aren't allowed to keep it. So the courts will suppress any parts of it before it gets to the defendant, if disclosure could risk privacy issues or put the victim at risk. But the idea is like once the sentencing's done, there's strict rules around that victim impact statement being returned to the court, and so the defendant can't hold on to it. It's one of the things, right? Yeah. So yeah, I think that's probably about all I want to kind of dive into there. So final exams, no, final exams, no, final exams, Jessica, final exams are 13 and a half hours long. So it's from, yeah, so 13 and a half, not 1.5. 1.5 would be a heck of an exam. That's like I'd actually love marking a 1.5 hour exam. It'd probably only be about a few hundred words that you'd ever get down, but you've got 13 and a half hours. You'll have, yeah. But we'll talk about exactly what the exam looks like next week, and all good. Yeah, absolutely do a glass of wine. I would be doing a glass of wine if I had the opportunity to. MRI. Name suppression. Up that, cool. So another point, potential input for victims, is when name suppression's at issue. So sections I mentioned earlier, sections 200 to 204 of the CPA, that deals when a defendant might seek permanent name suppression. And in those situations, it's up to the prosecutor to sit down with the victim and find out what they want, and then convey those views to the court. So that's like, I guess in a way, it's one of the only times that it kind of seems like a prosecutor is taking instructions from a victim. But really, the court want to hear the perspective of the victim in regards to name suppression, and rather than having the victim come in and give that, the prosecutor will do that, right? So then the judge then weighs that input as part of their broader assessment of suppression, right? So, and the test for a judge in that regard is whether publicizing or allowing publication of the defendant's name would cause extreme hardship or otherwise be contrary to the interests of justice. Okay. And that's effectively the test. I'm not going to examine you on name suppression, but that's where victims get an input. That's why it's been mentioned now. Temporary suppression applications, slightly different. They're generally a bit more procedural rather than, as you can imagine, permanent name suppression goes on forever. Temporary sits around the process, right? It's granted to protect the administration of justice. That's why we do temporary suppression apps. Okay, so in those cases, they might go and get, yeah, that's right. Well, they might go and get victim input for a temporary injunction, but it's not mandatory. It's not asked for. Whereas for permanent name suppression, it does. So, but it's definitely not determinative. Lottie, good question. Not really victim focused then for victims, name suppression. Yeah. Not really victim focused, but when it comes to, I guess the point is that when it comes to permanent name suppression applications, then in those instances, victim um, victim input is sought by the prosecutor. If it's just temporary, sometimes they'll ask, sometimes they won't. It's not mandatory. And again, but under neither of them is the victim's opinion on the matter determinative, right? It's just a tool to add weight. Cool. Okay, we might get through this. Here we go. Bail. How does that sit with victims choosing to forego? Yeah. It doesn't, and it's a great question, and this is the tension. Yes, if a victim wishes to forego anonymity and is saying, no, not only do I not want to be anonymous, but I want the and therefore and because within that I want the offender to be named. Courts still run the test as is there if permanent name suppression is not granted, is there going to be extreme hardship to the defendant or the defendant's family? Or is it in the interests of justice, which is still a very high test to grant name suppression? Because often if it's just an interest of justice test, it will be in the interest of justice to not grant permanent name suppression. So that's generally the less relied on test. The more relied on test will be extreme hardship. And if the defendant can show that having their name publicized will cause extreme hardship, not just hardship, but extreme, then it kind of doesn't matter what the victim wants. Permanent name suppression will be what will be given, will be granted, right? Yeah, more of a tikanga approach, right? Yeah, yeah. But yeah, with it, it's a yeah. We give the victims that voice, that chance to say, what they think should happen, and it goes into the melting pot, goes into the weighting, into the balancing, but it's not determinative, right? I guess it's just one of the things to think about. Yeah. Okay. Um, yeah. Oh, I'm still on bail. Yes. Okay. But there are other moments. There are other times when victims are heard, and so I've been talking about this within the prosecutorial process, where those moments are few and far between. This is kind of where they pop up more often. Bail, obviously, well, not obviously, but within the context of bail, victims are their views are taken into consideration quite a bit during bail applications, especially if the offence is violent or sexual, or if there's been a breach of something like a protection order, which then takes me to the second one. If there are protection orders in place, so if the court's considering imposing a protection order as part of sentencing for, in particular, say, family violence, it has to seek the view of the victim. That's part of the rules, legal requirement, not binding, but important. So within those kind of contexts, that's where the victim's voice actually has a much greater volume than in other moments throughout a trial. And thirdly, where a victim comes up quite a bit within the whole process is in parole. So when an offender prisoner becomes eligible for release, the victim has a statutory right under the Parole Act to make a submission. And so that can either be in writing or in person before the board. And one of the things to kind of think about is that happens every time a prisoner appears before the parole board, and that can be many, many times. As I said before, it's there about 4 times. If you imagine the victim having to, around about every 6 months or so, suddenly either write a new updated position, or actually appear before the board again and be re-question in front of a new panel. These are repetitions of trauma, right? And so we're putting victims through things again, and sometimes asking them to relive what often are the most traumatic times of their life. So we've got to be careful how we do that, and it's one of the critiques of the parole system is that is how we handle victim input into that decision. Yeah, and I guess these are all of those have to be made within kind of institutional boundaries. We build frameworks both to protect, protect the defendant slash offender slash prisoner from I guess any emotions that the victim brings with them. But as you'll have seen, kind of as time's worn on in our criminal justice process, we are starting to hear more from victims than we've heard before. 20 years ago, 25 years ago, we hardly ever talked about victims. So there has been a gradual, very gradual, just about glacial, but a gradual development of victim participation. And I, for one, would like to see more of that, but within boundaries, of course. I am going to run us through the last few slides, and then we don't have to come back next week on this, but we've got 3 more minutes, so let's give it a go. The Victims Notification Register. So victims of certain serious offences like sexual violations, serious assaults, anything that causes death, you can request to be put on the Victims Notification Register. Okay, so not everyone that's going to get that is a victim gets to say, I want to be on the VNR. But once you're on that, you're entitled to be informed about any kind of key events that happen in the life of the offender. So when they come up for parole, you're going to get told is the idea. When they, even if they get transferred to a different prison, you should be told. When they're eventually released, you'll be told. If they're convicted of any further offences, you should be told. So the idea is that victims who are on that VNR get kind of fair warning and a chance to make any safety plans that they might feel are needed based on what they get told about the particular offender. Okay, but again, as you can imagine, we hit this kind of familiar issue. While the Victims Code, and it's right 8 within the Victims Code, says that victims have a right to all this information, there's no real remedy if they don't get it. Right? So prisoners are paroled and released back into the community a lot where they have VNRs, they're on a VNR, and the victims don't know literally until the person's out wandering the streets again. And all they can get is an apology from corrections. That's it. There is no real enforceable, I guess, redress that goes with it. Okay, but for certain offences, if you're a victim, you can get on the VNR and find out what's going on with your offender. The Victim Special Claims Tribunal is it's more obscure, I guess, but it's a little bit more interesting. So under the VSC, so what you've got is the victim can seek compensation if the offender, that's the person who harmed them, later receives damages from the state for anything within and that's happened in the context of prisoners getting payouts for mistreatment in prison or for other breaches of their rights that then instead of getting, say, evidence thrown out, they get a payout. Or if they get, as I say, they get beaten up by guards in prison, and they get a payout, and that's proved, and they get a payout from the government that goes into a special trust fund, and the victim gets a chance to put their hand up to make a claim against that money, right? So, I guess that's the idea of it. Parliament introduced this relatively recently, not decades ago, and the idea is that if an offender suddenly has a windfall, then his victims shouldn't be left out to dry while the offender wanders off and makes bank while their offenders get nothing. That's the idea behind that. Okay, I think, and I'm on my last slide now. So I guess what I'd like to say about victims, wrapping it up, they are being increasingly acknowledged in statute, in practice, in the rhetoric, but acknowledgement isn't the same as participation, right? And participation isn't the same as power, as influence. Our system still treats the victim as a witness to the public to the public process, right? It's not a party to a private harm. So what happens is victims are sidelined, they feel unheard, and in general, pretty re-traumatized by the whole process itself. So my closing thought would be, how do we honor and expand the participation of victims without compromising the integrity and the value and the importance of the adversarial process and the protections that that brings to a defendant? So I'm going to suggest big questions. That's a big question, and there's brains much smarter than mine working on it, thankfully. But yeah, I think that's about all I have to say on victims today. That's us, 6 o'clock. I will see you guys next week at 4 o'clock for our last lecture. And I'm going to cover off some tikanga stuff. Then we will do a review, a bit of revision, a bit of a chat about how the exam's going to look, what you'll be thinking about. So I encourage you to be there. Yeah, up the wires, you'll never walk alone. Have a great weekend when you get there. Ka kite. See you later, everybody. Any questions before I go? Oh yeah, and great. Oh, marks too for the last 12 of you that are still there. I will get marks out in the next day or so. Thanks, Canvas. Sent me into a massive tailspin in the last few days. But all of your, for those of you, some of you might have noticed that Canvas has been a bit glitchy for the last, as I say, few days. I've managed to keep everything saved for you guys, so we'll just, your grades will be coming out over the next kind of 24 hours. Okay, but they're all very good. No one failed. In fact, yeah. Okay, so everyone well more than passed. Well done, everybody. Okay. Okay, see you all next week.